This channel does not promote any violent, harmful, or illegal activities. All content provided by this channel is meant for an educational purpose only.
Why lordships give dictations or writes the judgment? This is not like a scientist in the laboratory in a mathematical precision doing something. So therefore, every time when lordships judgments have to be understood, we have to understand the context and in what circumstances. So if I go the etymologically or deep, anybody can make a thousands of one different. But in this context,
synonymously used.
yes.
So does it mean that if there is total number of say 10,000 candidates,
Yes.
and out of which say 500 or 1,000 have been treated as tainted,
Yes.
then the other remains untainted or not specifically tainted?
Absolutely.
Right?
Absolutely.
If that be so, then the commission is coming out with a list of tainted candidates.
Yes.
Others become not specifically tainted or untainted?
Would your lordship say it once more, because I missed.
There are, suppose,
Yes.
in small figures,
Yes.
1,000 candidates.
Yes.
Out of them, say 100
Yes.
have been found to be tainted.
Correct.
That means the other 900 remains untainted,
Correct.
non-tainted, not specifically tainted.
Absolutely.
This is the
Yes. I think it is to my understanding, it is absolutely clear,
right.
because the lordship will see that as I was using the how the judgment of the Honorable Supreme Court was clearly resonating with the CBI's reports. It's not resonating differently. It's in the same frequency that I have stressed on the words all data of Pankaj versus all data of SSC. Then data of Pankaj was not tainted, and data of SSC, my lord, only used to match whom actually they gave the benefit because of the corruptions, and thereafter they found these are the corrupt persons. Kindly see, my lord, the deeper aspect of the justice delivery system. I was thinking this. On one hand, it is your lordship should be ensuring that any process is free from corruptions. Therefore, there has to be absolute thrust. No corruption slips through. No tainted slips through. Simultaneously, just for a hypothetical reason, assume of a candidate who is honest. Suddenly, for no reason, if he is stamped as a dishonest, in my most respectful submission, I would say that would be, if the justice delivery system is not, it does not protect that candidate for whatever reason, to my understanding, that would also be equal failure, because there are two sides of it. It's just to find out the good should be preserved, bad should go. So while doing the act of bad must go, there is a simultaneous, I would say it's a simultaneous also, that every time your lordships do so, also ensure that a good person suddenly for no reason doesn't become bad. So once we have been found to be untainted, which have been synonymously said to be not specifically tainted, today, based on an interpretation of 31, which is, I would say, 31, if lifted from the whole context, it is possible to give an interpretation of that. But if 31 is put in the place and read with 25, 22, 45 different treatment in 46 and 47, in my humble understanding, my lord, the only one and only interpretation is that if you are a corrupt, you are tainted. If you are tainted, not only you lose the job, you also return the money. If you are not a corrupt, we feel for you, but you also lose the job. If you are already serving, you get back, and not only get back, you get the continuity of the service. But since you didn't have a job earlier, for us, you participate afresh. This is in 51. That's the reason, my lord, I say that. No, then when 49, may I say 49? Before 49, just 51. So for returning money in 45, the Honorable Supreme Court found that the Honorable Single Judge was right, and therefore we are not interfering. Perfect. But then 51, the Honorable Supreme Court had to modify, because in modification has already been done in 46, 47. 46, 47, 46 for us and 47 for who also had a previous job. That's all about 51. Accordingly, we uphold the impugned judgment, cancelling a block entire selection process. This is the word. But have made certain modification. Rachime Kali Mark, according to my understanding, this is modifications is in 46, 47. In the direction issued by the High Court, because the High Court, in though when I read the judgment of the division bench, in fact, there is a possibility. My understanding was that possibly also High Court did not say so. High Court also, but maybe the language, there is a possibility in the High Court judgment to be read as if the High Court wanted everyone is tainted. But if the other paragraphs are read in context, that will not be the interpretations. But once the Supreme Court has said, well, there is no requirement, because 51, my lord, the upholding is, Lordship may kindly see the entire selection process, that cancellation, that's the upholding. But have made certain modifications means the 46, 47 and 49 that we can also participate again. So on this judgment, I will only say one sentence, and I will conclude on this topic. Therefore, my lord, the added respondents who have been appointed because of their merit in a better situation, my lord, they are untainted. It can be used as they are not specifically tainted, and therefore paragraph 31 of the Honorable Supreme Court judgment does not make them tainted. Paragraph 31 is only for cancellation. Now I will come to, well, I began first with this because if we fail on this point, then we fail everything. On this point, if we fail, in a sense, if in case there is an interpretation that in paragraph 31 the Honorable Supreme Court has said illegality, and therefore we are also tainted, and then the only, in fact, my lord, the situation is this today. Even the beneficiary of 47, because I am the in not in this matter, in another matter, there are about more than 200 persons who are working in madrasa. Now all prepared, everything is done, ready. Madrasa is also going to give them appointment because they had an old job. But now because of this, that whether persons who were appointed after expiry of the panel, are they tainted? If they are tainted, then they will not get any benefit. They should be denuded of all the benefits. They cannot participate. They have to return the money, all. So that is, in fact, everything is, as I said in the other matter, that even some schools, when they want to go, someone is saying, wait, let us understand whether the Honorable Court ultimately holds that you are also tainted or not. This is the situation. May I now go to the rule point? Well, before beginning on the rule, I shall be slightly using Usually, my lord, as a counsel,
Yes.
now, my lord, I shall be requesting your lordships for some time to use the lens of a mathematics, leaving aside the law for few minutes. And then lordship will have a very beautiful angle of this matter.
Yes.
Well, this is now I am on the rule. 10 marks. Well, I have studied the rule thoroughly, and I spend lots of time in the rule, and I had a couple of questions. Before lordship looks at it, may I just then I have tried to use, leaving aside the law. Law will come, of course, come, but I found mathematics is one of the best things by which we can look everything in an equal manner. So why not I exclusively use mathematics to give an to explain, does it really tilt? Firstly, does it tilt? Secondly, if there is a tilt for 10 marks, is it reasonable or unreasonable? That's a law point. Firstly, does it tilt? There are 100 marks. Out of 100, 60 is for written. Academics, that is qualification parts, that's 10. The bone of contention is 10 prior teaching experience. Now, when I say 10, I would be requesting your lordships to look at not as a 10. Look at, Kali, Mala, take the rule. Kali, straight away come to the schedule 2. Mala, that 25, that's there. Lordship will first kindly see. First, I would be saying on an area where there is no problem by anybody. That is educational qualification under 2A. Nobody has questioned that this is wrong. How much is the marks? 10 marks. Now, this 10 marks is to be given under 3 buckets. The buckets are 60% to 100%, he gets the 10 completely. And then second bucket is 60 to 50, he gets 8. And then 50% below. So if I put it this way, below 50, he gets 6 marks, 50 to 60, 8 marks, 60 to 100, 10 marks. So therefore, there is 10 marks spread over under 3 buckets. Nobody has any grievance on that. So everyone is recognizing that it is possible that if someone is better in the educational qualifications, his bucket may be different one.
This was not there in the 2016
This
recruitment rules. This bifurcation was not there.
these 3 buckets.
Right. Did you make any comparative chart between the
I-
earlier rules and
I,
the 20?
I did with the 2007, but I would do that.
Yes, please.
I would do that. I would do that. I was trying to, my lord, I was trying to, because my mind was to find out some mathematically first. I was trying to understand where do I stand from a neutral point of view. Thereafter, I will make my submission. I found for educational qualifications, there is a bucket, 3 buckets. So this marking. For prior teaching experience, my lord, that is more granular form. There are 5 buckets. Because it says
2 marks per year.
yes. So that means if someone has an experience of 1 year, he gets 2 marks extra. So when lordship is looking into this issue, it's not necessarily an issue of 10. There could be some persons who has only maybe 1 year or 2 year. It could be 2, it could be 4,
there can be somebody who has got below 56 marks
Yes,
and has 5 years and
exactly.
6 years
Exactly.
experience.
Yes,
So
yes.
gets the 6 marks and the 10 marks
Correct.
16.
Correct.
And somebody who's got above 60
Yes.
merit wise stays at only 10.
Absolutely. Right. 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 I was trying to make a contrast. Now, my lord, can you take my third page? Pagination. The last where the Roman 6:1.
Yes.
What it takes for a freshers to win. I was trying to understand the freshers versus we.
Yes.
I found some interesting mathematical thing. 1 year experience, it requires the freshers to get only 2 marks more in the written. So written is 6 times more powerful because it's 60 and this is 10. 6 times more powerful. In the entire selection process, if someone is a better candidate, in a sense, if someone has written 2 marks better than my lord, someone who has an experience of only 1 year, my lord, there would be a tie. For 2 year experience, my lord, freshers has to be better by 4 marks. And I have come to, for 3 years 6 marks, for 4 years 8 marks, and for 5 years experience, a freshers needs to answer better 10 marks. So if lordship kindly take Roman 7. What I am trying to draw is this. This means that written exam is 6 times more powerful than experience. The above example may demonstrate mathematically that number one, a freshers who performs well in the written examinations can easily beat even a candidate with maximum 5 years experience, but he has to be a better student. Number two, the experience advantage can be neutralized by scoring an equivalent number of additional marks in the written examinations. So it's not a dead end. It's a Darwin's survival for the fittest.
Here, everyday matters are moved for 1 mark.
Yes, correct.
In fractions
Correct.
and prior teaching experience, the maximum is 10
Yes.
and the minimum is 2.
Yes.
So it has a deciding factor.
It does. But I'm saying, lordship, kindly lift the veil of it. Kindly go into the factor. The factor is this. If you don't have experience, what do you have? For an example, my lord, many of us, if we compete today with a
Pressure.
10th semester law student,
Right.
I am
We fail.
100% sure that we will fail.
Yes, I know it. I am aware of it.
So therefore, life requires skill.
Right.
Now, skill can be said in thousands and one words. Experience is one of the expressions being used where it's a life skill, which is the truth. Now, if somebody has this skill of life to teach students, to match that somebody, one needs to be a better student. I could have understood that his door is shut. No, he has a 6 times more powerful avenues where he can compete. So therefore, the mechanism becomes this. If you have to compete with a person who has a skill, that's an experience, you have to be better in your studies. In 60s, in that, now kindly take the first page. I've tried to all the situations. Freshers versus 5 years. First, I've give first example is the example of tie. Freshers
Don't go to this such minute details possible.
No, I'm not minute, but I'm only trying to, my lord, because sometimes what happens, my lord, unless lordship is looking, if Lordship looks at the this issue, that there are so many persons who are having identical marks. This is on surface. If Lordship go deeper aspect of it, Lordship will find the performance of those so many persons. So my endeavor before your Lordship is this, that the performance, there are two sides of it. One is the skill side, another is you have to be a better student. I could have understood it is impossible that the written examination is not of 60, it is of 30. Then it would be a Herculean task, because my instruction is our total number of vacancies are around 35,000 and around 20,000 are actually they have got from the freshers, because freshers are always better in academic, bound to be. Well, their processors are always better than us. It is the normal thing. That's the evolution. But in that evolution, does it recognize the skill of experience or it does not? Or does that recognition of experience, does it make that competition so difficult for them that it can be said to be violative of Article 14 or not? To answer that in a deeper level, I say that if a freshers gets 48, when a 5 years candidate, I'm not saying even 1 year to 5 years candidate, he gets a 38, educational qualification, I take it everyone is getting 10, both of them will be having a tie, both of them would be a 58. And for a freshers to win, for an example, example 2 I have given, that in written examination, if a freshers gets 50, in that case he would be winning. And that the example with the 5 years. Similarly, for 4 years, to win freshers, he needs to have written examination 47, basically only by 2 marks. So sum and substance of this, my lord, that's why I said I would be using a little lens of a mathematics, that if Lordship look at a glance, of course it makes a difference.
And you have not added those marks which have been given to all on attempt. You have not added those marks, not even attempted but given marks. You have not added those marks also. The answer scripts have been published, and there are marks given. Two answers in one question is treated as right.
Okay.
Without even attempting, you are getting marks. Anybody who attempts also get marks. What is this?
May I say this? May I say
Yes,
this?
please.
Well, life will give thousands and one problems. Now, Lordship is already having won this because the Honorable Supreme Court has entrusted. It is impossible to solve every problem. Maybe that's also fundamentally not the purpose of life. I don't, that's the little, nothing to do with law, but something to do with beyond it. But making any attempt to solve a problem and assuming that the world would be without any problem, possibly that world may not be, because often I see this, that one of the beauties of the human beings that we are imperfect, because very soon we would be realizing when there would be lots of robots, there would be complete perfections, maybe one would be exactly like others. So all I say, no matter how much efforts are there, there would be some mistakes, there would be some problems, there would be some kind of imperfection. Maybe life is all about that. But when Lordship is looking into the rule to test it whether it is to be declared as a violative of Article 14, then Lordship also draws the very philosophies from the life itself, which has one component of you have to be a good student versus do you have a better skill or not. So if the state, if they have chosen, in my understanding, rightly chosen, but there can be a different possibility also, that I want to give 2 marks, 4 marks, 5. I'm not using the 10 marks deliberately because it's not directly 10. So I want to recognize and give some weightage to a person who has a skill. Is it fundamentally flawed? My lord, my respectful submission before your lordship would be, possibly this is fundamentally, it is possible that when a corrupt institution does so many corruptions, then there is an every apprehension that even a good thing they might make it bad. I understand that. I do. I can't talk out of. It's true, but looking from the point of view of the constitutionality and legality, recognizing the experience, which is a skill itself, that itself, now that could have been, I would say, that could have been violative of Article 14 had there been no field for 60 marks in the competitions. I say that what does it make? What is the impact of it? The impact of it, the competition becomes harder for the freshers, meaning thereby, if you are a fresher, you have to be a better candidate. You have to be academically better than a person who was working. So therefore, choice which is being made by the state, that we do recognize the skill, therefore we give an weightage. And because we do this narrowing, we are making it harder, we are getting better candidates. But ultimately it is 35,000. Even if I don't know how many lakhs, I assume there may be lakhs and lakhs persons. So therefore, only the persons who are better, and within the better, for the timing, assume that 10 marks is not there. Then what happens? Many of the candidates who had the experience, they will not be able to. Why? Because in that case, this I would say this intangible part of it, well, the educational qualifications is a very tangible one. He got this percentage of marks, very tangible. But the experience, now if someone asks that you have practiced law for 7 years, 10 years, versus a person who is excellent, he might be first or second in his class, just passed law. What's the difference between these two persons? Well, there are, we recognize, sometimes we may not be able to articulate it, but we really do understand that while dealing with the problems of life, the persons with experience might have some age which is fundamentally very intangible, and recognition of that age which is intangible from a source of persons who have been screened and found to be not tainted, and coupled with others, because of course it's not us, anybody, there may be others also. Mr. Mitro has also said, lordship might definitely say that they have made it is hard competition for the freshers. Yes, they have to 2 marks extra, they have to have 4 marks extra, but still there is a huge avenues for that. That's the reason 20,000 of them, they are there. So if you, lordship, take it that way, 35,000, so freshers are 20,000, so it's there are huge number, more could have been there. So lordship might see that it is itself is not flawed, could have been flawed had there not been a 6 times more powerful avenue of written examinations. So therefore, fundamentally the rule, if I can say this way, fundamentally the rule chooses the best person. They are getting the best students from freshers, and they are also getting, I would say, average or lesser best, but with a better skill, which is Also the other aspect of Article 14, that we are recognizing that there is some amount of not equality. Someone having experience of 1 year, 2 years, at least he knows how to handle with students. He knows a couple of things. So therefore, they being not equal. I would say that Article 14 has been translated into reality, and that has been spread over and sprinkled in this variety of the schedule. Well, I will make a comparison on 16 and 25 also. Now, my lord, may I go to the rule itself? Well, there are since I was making submission on the rule itself, I thought if I make the submission on the rule, and when I go to the judgment, I will go to the judgment touching upon all these topics. Well, my respectful submission before your lordships on the rule dealing with the point at what stage is that the rule itself is absolutely clear at what stage, and that stage is before interview. And why do I say it is before interview? That's the my answer. First, I say that in every rule there are definitions, rule or in the act, and there are substantive provisions which operate, and there are schedules which are for more minute details how that operation will take place. Here also there is a definitions which is there, I would say they are banking on the writ petitioners. But there are substantive part. First, may I, the definition, Lordship would first kindly see that starts 2(1). In these rules, unless the context otherwise requires. There are judgments, I shall be giving it later on. So therefore, the very definition clause begins with the understanding of flexibility of the definition itself to say that do not read the definitions in contradictions unless that context requires so. I give you a definition, but that is not an watertight. It is flexibility and it has to be in sync with the context. With that 2(1) broad head, now comes 2K and 2L. Now first 2K, interview list. Interview list in respect of the SLST state level selection test means in case of vacancies in the post of assistant teacher, a list of candidates prepared by the Central Commission to be called on merit for oral interview. So kindly mark for oral interview and lecture demonstration, not post, category wise on the basis of preliminary merit score, that is score from a written test. In this case, state is not relevant, and academic score in the ratio of 1.6:1. That is for 160, 100 of final vacancies. So this is the definition of the interview list. Well, it doesn't really say where to operate, where to be done. And thereafter, this is the merit list, which is the writ petitioners have, they have banked on. before my lords, referring to merit list, the substantive part, if your lordships kindly have a look at, lordship will see there is a separate substantive rule for merit list and there is a separate substantive rule for interview list. For interview list, the substantive part is there. Rule 11, sub rule 8. Before reading it, lordship may kindly contrast it with sub rule 16. This deals with the merit list. After interview, Roman 16.
Roman 16.
Yes,
After.
I was on rule 11,
Yes.
Roman 16. Because I want to answer first what they have formed. After interview, the interview board shall forward a detailed report to the Central Commission, which shall, from the interview list and on the basis of the report of the interview board, prepare and publish a merit list category wise on the basis of the merit as per Schedule 2. The merit list shall contain the names of all. So therefore, under the substantive portion of the rule, there is a specific portion where merit list has been used, that is Roman 16. Whereas, kindly see my lord, Roman 8. The Central Commission shall prepare and publish in its website a preliminary list with details of the candidates to be called for interview. So therefore it is for interview clear, subject to verification of credentials, not relevant, and eligibility category wise. On the basis of preliminary merit score, I could have understood it is ended here, but no. As defined in Rule 21K, kindly, my lord, kindly see the absence of K. The absence of K is there. Sorry, I just, absence of L is there. Sorry. I was, the expression of your lordship, I often, my lord, I do say, words are most of the times not the thing itself, it carries what is something, I don't know whether should I use the word inside or. So when even in our conversations, we know every little and our whole system understands. I understood that I was making a mistake from lordships. So L is not there. So absence of L, what is to be done, what list to be prepared for interview, the rule itself is clear.
Yes.
I would say this way. Absence of L justifies presence of L in Roman 16. And that makes it clear that Schedule 2, now lordship kindly come to Schedule 2 sequence. So that's the entire context and objects ought to be achieved. That the substantive portion of the rule refers the interview preliminary list only. It doesn't refer about the merit. And then the sequence part lordship gets it in Schedule 2. Well, Schedule 2, to my understanding, the sequence is so clear that it says, I would say, kindly look at the first, the number. Number 1 is the written examination. So that's the area where one has to be the best. 6 times powerful, as I said. And number 2, that's the number, academics, has 2 components. It's a small a and small b. The small a has 3 buckets, which can also be said to be arbitrary. Somebody can say that I am getting 80, so therefore 60 plus and even 100 are in the same bucket. It's possible. So that's why I made a comparison that prior teaching, that is more granular. This is more compartments are there. But Lordship may also consider that if we call it arbitrary, I don't want to call it arbitrary. If we philosophically, not legal arbitrary, if we call it arbitrary, but there is always a point which can be said to be arbitrary. If Lordship draws from life itself, which is the part and parcel of the law, that I do believe, then somewhere there has to be a full stop. Somewhere there has to be some kind of collateral damage which may not have any legal right, which has to be accepted. There may not be a law which would address for every individual variety circumstances. Somewhere has to be, but effort has to be made. Is it so wrong? Or no, some efforts have been made. For an example, for educational qualification, I would look at, it is fair enough. Yes, could have been even the 5 buckets. I don't mind it. But I would say that it doesn't make you of that kind of candidate that who would say that it makes that competition level of 60 marks becomes harder. Yes, it puts you with some others in the same bucket because it is only 3 buckets, not a 5 or not a 6. But still, if you feel that because your educational qualification was better, you are a better person, compete better, become a better student actually in the examination itself, that scope is there. Therefore, existence of that scope, which is same for everyone, neutralizes quote and unquote arbitrary. Can I resume?
Yes, it's nearly 30.
Yeah, that's what I'm saying. So, not it's 30.
One.
No, but it's a 30.
Yeah, it's 30.
Word. Yes.
When to resume is the question mark.
Saturday.
Don't block the court. You all may come. It's absolutely difficult now.
And my lord already in Panchayat
No, no,
matter
Smith,
going on.
no,
My lord already had that matter the whole day.
Well, I have always opposed to the Saturday course because Saturdays and Sundays are
No, no.
the busiest for us.
True.
Busiest for it.
But wait. I am a believer of. I don't believe that this theory of doing everything. It makes a person ultimately at some point very troublesome. So we should take rest. Lordship should also take rest.
The mind should rest.
You need your mind to at least
Yes.
recover,
Yes.
Absolutely.
to repair,
Absolutely.
to learn,
Yes.
unlearn, relearn.
That's why our holidays are
So-
very
Extremely.
It does. It does.
that the common public doesn't realize that. Even the government says that we should be working 365 days. We are not machines.
Yes, we are not.
You read a draft, you leave it aside for 2 days, you read it all over again, and you see so many flaws over there.
Malad, in argument, our finest arguments come in course of arguments.
Yes.
Absolutely.
It is in the
At the time of
it
preparation,
is
it
in the
doesn't come.
interaction. That's I think
This is
most
what is experienced.
yes.
And that is why 10 marks is required.
He
that
will
is
make
true.
out his case wise.
No, not
Like
let's look.
Dr.
We are ultimately, Milo, dealing with raw life. That's good that we don't want to be touched because then we will have an emotional breakdown. So we have to say law. I mean, it's a law, but ultimately, Milo, it touches upon this. That whatever our understanding, those are in a different package. We call it law and differently, so that good remains better.
সেটা একবার জিজ্ঞেস করে দাও। দাদা আর কতক্ষণ লাগবে?
Tuesday.
How many are there this side so that I can start with the rest?
I will take not more than 15 minutes. I assure your lordship.
Because more or less all points are being
Yes, that's
covered.
exactly why, my lord, I will not take more than 15. Sir, আমার পরে
The Sanyal, where is he?
Please not present at court.
Not here. How long is he likely to take? Any idea?
Not yet, perhaps 30 minutes, because the judgment part has already been cited by Mr. Mitro. So he will only argue on the rules according to whatever instruction I have been received from Mr. Sharna.
Mr. Mitra and Mr. Dhara covered roughly
Rules
everything.
also,
That's a few
judgment.
bits and bits here and there, and that's about it.
Well, may I make a very humble prayer, because there are some cans. What happens that they filed it, it is there. Lordship
Not in
kindly
the
also.
list.
No, it is in the list itself.
Formal order is required to be passed for addition.
All AORs are also there. We are so
Yes.
they have to also.
Addition.
Yes, only addition.
All right.
And another
Item 14, can 7. Can 7.
Lord, my can, your lordship has added me, but it's not showing in the list.
That is the reason.
add করে দিয়েছে বলে দেখাচ্ছে।
Added this post, it's not there in the list.
Yeah, that's okay, because
Ah.
The files.
We have been added as parties.
Thought
That-
I
that-
even made that.
once you are added to,
Perfect.
you are
All your files are here. All your files are here. Your opposition, you all can come up with. The additions, formal additions will be made.
Whatever is on record, on the basis of that itself.
Yes, yes, yes.
My understanding whether advocate on record add by own.
No, no, the department will add.
that direction was there.
Step. But since the files are here, possibly the formal addition has not been done, the files are required to be sent to the department, then only they can add it. Right?
Extremely grateful for that.
Yes, yes. Not you, it is the department who will do. Don't take it on your shoulder.
Yes, yes.
তুই সবকিছুই নিজের উপর নিলি।
Item 10. HUD submission made on behalf of the, which application is yours?
Well, this is
Item
submission I made in item 13. And this time for addition, I am seeking item 14, can 7.
I am in item 10
Lordship is still putting everything in
all together, but then
because it's not separate.
I have not made any order with all the
My one
numbers
application,
together.
Kindly, because one applications, Lordship kindly also understand the AOS. They have to, this application is pending, so as if nothing is happening, so.
No, no, I'll add them.
Nah,
I'll add them. But then in 10 you are not there.
no, I am there in Rahul, 13, 14,
13.
12, I am 12, in 12 there.
All right.
10.
10 you are there. Application number.
Can 1.
Acha, HUD submissions. Now, learned senior counsel concludes the submission. Senior counsel of the applicant in can 1 concludes submission. ঠিক আছে? Released for further argument on blank. 11. Any applicants?
No.
নেই তো? It will remain in the list. 12 you are there.
Yes, I'm there.
Which application?
No, 12 application already allowed.
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 All right.
12, Lordship may record that I have filed the opposition to the.
12.
Yes.
All right. 12 will get affidavit in opposition filed by the added respondent.
Either.
Under the back sheet of Sakhawat Khandakar is taken on record. It will be open for the petitioner to file exception to the same.
তো মৌসুমীর মামলাটাই আমাদের
List for further hearing on blank. যে ডেটটা দেবো সেটা সবার জন্যই যাবে। 13.
Same order.
Well, can 5 allowed?
Can 5 has been allowed.
Same order.
Same order.
List for hearing on. List for further hearing on. 14.
14, my lord, 14 only, I am sitting, there
Can
is a can,
7?
can 7.
Can 7. Can আগের order আছে আপনি দেখে নেবেন. Can 7 is allowed. Department to make the necessary addition in the cause title of the writ petition. Stop. It will be open for the applicant to file affidavit in opposition. 15.
15, I am for the petitioner. Well,
Yes.
the can has been early added, but no opposition has been filed.
You want to file, you file it because
Well, I am
there
the
is-
petitioner. Well, the can
oh, you are the petitioner. Then the direction for opposition is possibly there.
no, this is matter is different.
Different.
Because, yes, well, the double benefit. Well, the 9.
Yes, 9-10 experience
That's
cannot
not-
be.
But a senior friend also appearing in this matter.
Yes.
ওটা তো আছে, কোনো ব্যাপার।
So we'll take it up separately. 15.
No, this is the matter is going on same, but they are want to file the opposition and then file it.
If they want to file, they can file it. No difficulty.
No difficulty.
But then no order is being passed in 15 now. 16. All these 16 and thereafter no order is passed. No addition of party is also there.
There is one 18 there opposition kindly.
18 mile we have an application.
That was already allowed, only opposition.
Anybody filing it today?
Yes, yes, yes.
Oh, ligan in the item 18. Which applicant?
Well,
There I
application-
can see 4. None has been allowed possibly.
No, in 18 allowed.
18 opposition.
No, 18 it was allowed. I was can 2.
And can 1, 3 and 4 is anybody there in item?
Can 3
Yours.
yes,
All application for addition of party?
yes.
All the 4 cans in item 18 is allowed. Formal order করবেন কিন্তু আর অপোজিশনের ডিরেকশনটাও দিয়ে দেবেন
এই মৌসুমীতে ক্যানটা অ্যালাউ হয়েছে
after 18 no other matter
23
23 there is, but I am not confident
23
about.
Mosumi Mondal, remember that matter goes up to Supreme Court. Supreme Court order it is mentioned.
23
23.
Position.
In 23 well, we have filed an application.
Or I not get yet the copy.
copy all copies to be circulated
Yes.
please item 23 record an order opposition by the applicant under the back sheet of such and such কোন অ্যাপ্লিকেশন উপর লেখা থাকলে ভালো না হলে ব্যাকশিটটা দেখে করে দেবেন ঠিক আছে যেটা যার যাতে সেটাতেই যায় টেক কেয়ার ঠিক আছে আচ্ছা
এই না 21
23 হ্যাঁ রিপ্লাই
But
থাকবে
there is one can 1 that needs to be allowed.
23
Yes.
yes all cans allowed 23 cans allowed no further ঠিক আছে
Deeply
Your
agreed.
Lordship's query was well, in 2016 rules whether the segregation of marks for academic qualification was there or not. It was there.
it was all right
It has been annexed in item number 10 also. Well, page 350.
a chart
I'll prepare a chart.
Difference.
Yes.
Annex the 2016.
no
It's not
a comparative chart
Well, I will do that. I will do.
yes
The
please.
chart in the petition itself.
All right when do I fix it
Which day?
One day.
don't block the Monday
No, Monday. Don't do. Monday. Let us
Tuesday,
also do some other.
y'all yes exactly
That's-
y'all also have other matters
Yes, but I'm saying.
do not keep yourself blocked over here
Twist
Item
it,
number
twist
17, Maladu, remember that with the previous matter.
Let us finish this matter first.
yes when do we keep it
Tuesday.
Tuesday
Tuesday.
9 the AG is sitting behind I cannot see him I do not know whether you'll get a chance on Tuesday or not all right then the commission is also there commission is to be heard Tuesday 9 সবগুলোতেই 9th করবে
Item number
17
getting the key number. The validity of substitution beyond the last card because verification is.
yes
Then I'm not.
tomorrow Tomorrow means the next working day, Monday. All right, all right.
Otherwise,
17 নম্বরটাকে সোমবার দিন, কারণ অন্যগুলো তো 9 তারিখে হয়ে যাচ্ছে, তার মানে ওটা আগে উঠে। Come up.